Hey everybody, my name's Alex Berger. Welcome to, I think, what is the final session of the conference. So thanks for staying strong and coming to my presentation. I appreciate it. We are going to be talking about hemp-derived products and the FDA, what the FDA can regulate, what they most likely cannot regulate, and a couple of sort of in-betweeners. So like I said, my name is Alex Berger. I'm an attorney with Emerge Law Group here in Portland. Emerge Law Group is the first full-service boutique law firm that specializes in the cannabis industry. We also have attorneys in California and Illinois. My specialty is regulatory compliance in the medical and adult use marijuana space, as well as regulatory compliance in the hemp space on both the state and national level. So like any good lawyer, I'm starting with a legal disclaimer. None of this should be construed as legal advice. This is for informational purposes only. None of you are made my clients by any of the information I share with you. There's no attorney-client relationship yet. I'm also, just to make this sort of, easier to understand, there are very complex laws when it comes to the FDA, and so, I'm going to be making some generalizations and simplifying things so that hopefully they're more understandable. And laws and policies are new. I mean, this is a new industry for the federal government to grapple with, as well as, industry members. So many times I've been on the phone with people from, regulatory bodies, both nationally and statewide, and sometimes they don't even know the answers, frankly. And just remember that legal advice generally is always very fact-specific. So not everything I tell you is going to apply to your particular situation, which is why you should always get your own counsel, share with them your vision, what you're trying to do. And I did not tell you to do any of this. It's your decision. Ultimately, you guys are the ones who are going to be taking the risk. So again, I would encourage you to engage your own counsel before, jumping into some of these waters. So why does the FDA matter? Well, what does the FDA do? The FDA is the Food and Drug Administration, and for our purposes, the FDA regulates the interstate commerce of certain products consumed by humans and animals. What products consumed by humans and animals does FDA have authority to regulate? So there are 9 categories: food, dietary supplements, cosmetics, drugs, and then 5 more that we don't really care about all that much, which are biologics, medical devices, radiation emitting devices. Can anybody guess what that would be? X-ray machines, that's right. And also something else in the kitchen. Microwaves, also correct. And then veterinary products and tobacco. So what existing hemp-derived products consumed by humans does the FDA regulate? So in terms of food, anybody? Food that the FDA regulates that includes hemp-derived products. What's that?
Hemp seed.
Hemp seed. Yes, hemp seed is certainly an ingredient, definitely. Well, I didn't think it would be that difficult, but we have CBD chocolates, gummies, water is technically a food under the Food, Drug, and Cosmetic Act. And then, what about dietary supplements, or what we think of as dietary supplements? Just let it out.
Protein powder.
Protein powder?
Tinctures.
Possibly. Tinctures, maybe, yep.
Capsules.
Capsules.
And
Tablets, most likely, yes. Capsules, tablets, oils. What about cosmetics?
Topicals.
Topicals, yeah, basically. You got CBD creams, sprays, balms, etc. So these are products that fall within, there's one more. Drugs. Does anybody know? I'm sure you've heard this drug over and over again at this conference. Epidiolex, that's the one. Not the most, that's also true. Yeah, I mean, I guess that's not necessarily hemp-derived. I think that might be marijuana-derived and has THC in it, but absolutely, yeah, that is a drug that FDA has approved and regulates. And technically, FDA can regulate any article intended to treat disease or affect the structure or function of the body. That is the definition of a drug, which will come into play a little bit later in the presentation. So FDA matters because it regulates many hemp, including hemp CBD, products consumed by humans and sometimes animals, placed into interstate commerce. And for the interstate commerce piece, everybody wants to sell their products throughout all 50 states, the planet, the galaxy. So when does FDA have limited authority? Well, what hemp-derived products consumed by humans does FDA likely not have authority to regulate? Smokables, usable hemp, pre-rolled joints. That is not a food. That is not a dietary supplement. That is not a drug if it's not intended to treat disease. Can anybody think of another one possibly? Vape pens, yes. Vaping products, including CBD oil cartridges and distillate, etc., in my opinion, do not fall under any of those categories. FDA may disagree. As we all know, sometimes federal agencies overreach their own mandates.
No.
DEA comes to mind. So I have a little asterisk here that it may be considered a combination product. For example, a drug and a medical device morphed together. But the FDA has not come out and said that. And it's certainly not a tobacco product, so it can't be regulated like e-cigarettes. There are some caveats, of course, to these, which is state laws, right? You could be okay federally, but Texas, Louisiana, Indiana have outlawed smokable hemp because it looks too much like marijuana. They don't want their state police to be confused. There's a question as to the constitutionality of that, however. Is it my fault that a cop doesn't know the difference? I don't think so, especially since one is arguably federally legal and the other one is not. We still have toy guns. We run around with toy guns, unfortunately. Depending on your attitude toward that kind of thing. But those are not made illegal just because they look like real guns, right? And a judge in Indiana actually agreed and stayed the ban. I'm not sure exactly what the posture of that case is right this second, but the key is know your state laws where you're selling as well. And then, of course, vaping has taken a couple of hits, so to speak, over the last 6 months or so, with the lung condition that has been traced to adulterated vaping products. And so some states and local jurisdictions have also banned vaping. So be aware of the state laws as well as the federal laws. Cosmetics are special. The FDA technically has authority over cosmetics. However, they are not subject to pre-market approval by FDA, as are some foods and dietary supplements. And the FDA has come out and said that cannabis and cannabis-derived ingredients are not prohibited or restricted by regulation for inclusion in cosmetics. So that's one reason. I don't know if you guys are aware that some major publicly traded companies are starting to sell these things in their stores. Walgreens, CVS, but you'll notice that they are cosmetics only at this point, and this is the reason why. Of course, there are always caveats. So you can put a hemp-derived substance into a cosmetic, but the cosmetic itself can't be adulterated or misbranded. It's still got to be safe. It can't contain any poisonous or deleterious substances. And then again, I'm going to bang this home probably during 5 to 10 slides. if you make health claims for any product, with an exception that I will note later, the FDA may consider the item to be an unapproved drug regardless of the administration method, right? So even if it's a cosmetic, even if it's a sublingual spray, it's really the intention of the item that makes it a drug in FDA's eyes. And we'll talk about how that intention is communicated. So why else does the FDA matter? Well, it specifically prohibits the addition of CBD-specific products to certain products that it regulates. So food is one example. I'm sure many of you are aware of this. But according to the FDA, CBD specifically cannot be added to food in interstate commerce because it's an active ingredient in an approved drug, which, everybody say it, is Epidiolex, right? And Epidiolex is an approved drug and was also a new drug subject to clinical investigations made public, and those substances cannot be added to food in interstate commerce, according to the Food, Drug, and Cosmetic Act. Secondarily, dietary supplements. If CBD is added, then, according to the FDA, the product ceases to be a dietary supplement because it doesn't fit under the definition of dietary supplement in the Food, Drug, and Cosmetic Act, which it's basically for the same reason that it can't be added to food, because CBD is an active ingredient in a approved drug, and a dietary supplement, by definition, cannot have an approved drug as an ingredient. But it's a little strange here because, okay, so we know that it doesn't fall under the definition of dietary supplement, but the FDA hasn't really come out and said what law that breaks. I mean, it just doesn't fall under the definition of supplement. Okay, so why is that illegal? I'm not sure why they haven't come out and really stated what law one would be breaking. I would think that would, give them cover to do that. My guess is that to the extent that it does violate the law, it would be misbranding laws, right? If you're calling something a dietary supplement on your label and you have, there are other aspects of the label that lead somebody to believe that it is a dietary supplement, then it may be a misbranded dietary supplement in interstate commerce. So that's my guess. So when else does FDA have limited authority, though? So what are the commonalities regarding, what I just mentioned, which was adding CBD food and dietary supplement to prohibitions? There's one phrase that I highlighted a couple times. It has to do with where these products are marketed, distributed.
Interstate?
Interstate commerce, exactly right. And then the second one is the Epidiolex related item, right? An approved drug or new drug for which clinical investigations have been instituted and made public. So let's take the first one first, right? Interstate commerce. Interstate commerce is quoted in the Food, Drug, and Cosmetic Act under their Prohibited Acts section. So basically, this is what is illegal under the Food, Drug, and Cosmetic Act, and this is the section that the FDA cites to when they send warning letters to CBD manufacturers, warning them that their products are illegal, right? So in the Prohibited Acts section, for misbranded dietary supplements and for adding drugs or new drugs to food, it always says it is a prohibited act to add a drug to food. I'm paraphrasing a little bit here. It's really the introduction or delivery for introduction, into interstate commerce. That is the prohibited act. And then the meaning of interstate commerce is technically commerce between U.S. states and territories, commerce between U.S. states and territories and anywhere outside, and then commerce within Washington, D.C. and territories. But for all intents and purposes, it's commerce between states and commerce from a state outside of a state, unless you're unfortunate enough to live in Guam or whatever, and then basically federal law applies. So, logically, if no CBD food or dietary supplements in interstate commerce, then what can you do? What does FDA not have authority over? If their authority is restricted to interstate commerce, that's right, intra-state commerce, selling, manufacturing, distributing, and selling all within a state. FDA doesn't have authority over that because we have, separation. There's a constitutional aspect, but I mean, the federal government cannot regulate everything that happens within a state. States' rights, sometimes they're good, sometimes they're bad. Sir?
What body regulates it within the state of Oregon?
Great question. Within the state of Oregon, that would be the OHA, the Oregon Health Authority, and ODA, Oregon Department of Ag. And so I'm glad that you brought that up. Sorry, the question was what state. We're recording this, so I have to repeat back into the mic. But the question is what body within a state regulates food, dietary supplements, et cetera. And so, that was my first caveat, is that, again, state law may differ from federal law. Or maybe the same as federal law, as in California. California, in their food law, they adopt federal regulations. So the California Department of Public Health came out, I think it was about a year and a half ago, and they said you cannot add hemp-derived CBD to food products because the FDA doesn't allow it. And I'm not saying that they're too lazy to write their own regulations, but they just said we adopt federal regulations wholesale. There was an attempt to change that with a bill late last year, but that did not pass. So as of today, California, you cannot add CBD to food products. The difference in Oregon is that the Oregon legislature specifically exempted hemp and hemp products and commodities from the definition of adulterant in terms of our food law. So in Oregon, you can add hemp-derived CBD, assuming that it was legally produced, et cetera, to food products. Another caveat is that the FDA as an agency still retains some authority over purely intrastate commerce. There was this ridiculous, in my opinion, Supreme Court case that everybody studied in law school called Raich v. Gonzalez, where under the California medical marijuana program, 2 patients were growing their own marijuana, consuming their own marijuana, consistent with California state law, and the Supreme Court found that the DEA still had authority to regulate that purely intrastate commerce, which frankly wasn't even commerce because they weren't selling it to anybody, right? They were just consuming it for their own medical needs. And the part of the rationale was that if all states in the aggregate allowed medical marijuana, it would substantially affect the illicit national market of marijuana. So they really bent over backwards, I feel like, to come up with that. So long story short, FDA retains some authority over purely intrastate commerce, but again, the Food, Drug, and Cosmetic Act itself, which gives FDA authority to enforce these prohibited acts, specifically states in interstate commerce. So FDA, is tied to that. Another caveat, FDA's position that everything is interstate commerce. There's one publication about cosmetics that states that FDA's opinion is that interstate commerce applies to all steps in a product's manufacture, packaging, and distribution. Some ingredients or packaging is likely to originate from out of state or out of the country, and that it's foreseeable that a product will leave the state. That's not written in law anywhere. That's not written in regulations anywhere. My position is that that's not necessarily true. Everything that you buy anywhere, it's foreseeable that it could leave the state. We border Washington. So, and then last caveat here is that other FDA requirements may apply. CGMPs, does anybody know what CGMPs stand for? That's right. Current good manufacturing practices. So those apply to food manufacturers of a certain size, arguably regardless of whether they're engaged in interstate commerce or not. You can get certified by a third-party certifier, and that doesn't necessarily mean that you're on FDA's radar. So let's talk a little bit about the second part of the prohibited acts, right? Engaging in interstate commerce was the first part. The second part is adding an approved drug or a new drug for which clinical investigations have been made public. So the reason that you can't add CBD to food or dietary supplements, as I stated before, in interstate commerce is because CBD is an active ingredient in Epidiolex, an approved drug. So that's that. Yep, that's what I just said. Okay, so question number 3. If CBD is an ingredient in approved drug and the subject of publicized clinical investigations of a new drug, what does that leave? Remember, this applies to CBD, right?
Just put all the other cannabinoids in there now.
Possibly, yes. Other hemp-derived ingredients that are not contained in an approved drug or subject of publicized clinical investigations. So according to experts, I am not a scientist. That's why I went to law school. I'm terrible at math as well. But according to some experts in science, there are over 100 cannabinoids in hemp. So again, I'm not a math major, but I'm guessing the odds are that not every single one of those cannabinoids are in an approved drug or in an investigatory drug. There is, on the FDA's website, there's a list of articles that are investigatory new drugs that have instituted clinical trials and have publicized that fact. So this is where you still have to deal with the FDA. So a new ingredient or food additive can be added to food if it's generally recognized as safe or GRAS. And a new ingredient can be added to a dietary supplement if you notify FDA ahead of time prior to marketing that dietary supplement. So let's start with food additives. So the GRAS process requires that you submit a notice to FDA with scientific descriptions of the new ingredient, safety data, known toxins, if it's botanical, the genus, species of the plant from which it derives. And then if the FDA response is not a denial and they don't ask any further questions, or if you answer the further questions and then they don't deny, then de facto it is an approval for manufacture and use as a food additive as described in the notice, right? So you have to stick with how you notified FDA that you're extracting it, manufacturing it, what have you. And there are 3 GRAS-recognized hemp-derived ingredients. And those are what some of you guys named at the beginning: whole hemp seeds, hemp seed protein powder, and hemp seed oil. And so, interestingly, the GRAS notices include that there may be trace amounts of THC in each one of those. FDA didn't have any questions. So I think it's certainly possible that if you can provide the substantiation that this product is safe, that you can get a certified GRAS designation for a new hemp product, and then you can add it to food, throw it into interstate commerce, have fun with it. So for dietary supplements, dietary supplements are different than food, although they fall under the food category technically. The FDA is not authorized to review dietary supplement products for safety and effectiveness before the product is marketed. So you don't have to necessarily go to FDA and, prove the safety, the efficacy, all of that before the product is marketed. If the dietary supplement contains a new ingredient, however, you must notify the FDA about the new ingredient prior to marketing. But FDA reviews it not for approval, just for safety. And so again, you want to substantiate. You want to substantiate that the ingredient is safe. Of course, we have caveats as usual. You're still responsible for making sure that your product is safe, regardless, right? Just because pre-market approval is not required doesn't mean that the FDA, walks into Walgreens every once in a while to see what these new dietary products are and to regulate them. There are certain labeling requirements. You have to call something a dietary supplement if that's what it is. You can use herbal supplement, hemp supplement potentially, but that supplement's got to be in there. And you can't make any disease claims, so you can't say that, it treats cancer or it helps with fibromyalgia or something like that. But you can use certain structure function claims so long as you notify the FDA ahead of time and you use that classic disclaimer, which I still have to read amazingly. This statement has not been evaluated by the Food and Drug Administration. This product is not intended to diagnose, treat, cure, or prevent any disease. Basically what you see on vitamin labels. And you should have scientific data to back up the structure function claim. Let's see. Okay, so why else does FDA matter? Drugs. Even if a hemp-derived non-CBD ingredient is lawfully added to a food or is a new ingredient in a dietary supplement, FDA still may consider the product to be an unapproved drug. Drugs must be pre-approved by FDA for safety. There's all sorts of very, very expensive tests that have to be done. You need experts, all sorts of things, and it can take years and years and years. I think GW Pharmaceuticals, which is the manufacturer of Epidiolex, started instituting their clinical studies, I think it was in the aughts, so 2007 maybe, and it was only approved in 2018. So again, drug, for our purposes, is defined not necessarily by the administration method, how you take it, but by its intended use, right? Intended for use in the diagnosis, cure, mitigation, treatment, or prevention of disease, or intended to affect the structure or any function of the body of man. This was written in another time, obviously. But with that one exception for new dietary ingredients in dietary supplements, right? So how does FDA determine intended use equals a drug? How do they know what the intended use is? How could they know? Advertisements, that's right. Health claims, right? So as I said, regardless of the form of the ingredients or the administration method, if you have health claims, the FDA will likely consider the item to be a drug. And it's really been the health claims that trigger these warning letters, right? Like FDA has limited resources, which is one of the reasons that they don't require pre-market approval for dietary supplements. If everybody who had a new dietary supplement needed pre-market approval, I mean, the vitamin lobby would freak out. And so they use discretion when they enforce. And the former head of the FDA basically came out and said, look, we're using enforcement discretion, right? And the easiest way to use enforcement discretion is to go on a website and see what the marketing materials say. So some examples of health claims are, and these are taken from actual warning letters, are from antibacterial, inhibits cancer growth, reduces risk of artery blockage, treats fungal infection, treats psoriasis, promotes bone growth, which would be probably not a disease claim, but would be a structure function claim. And this is key. the FDA looks at everything, right? Not just your label, not just what's on your website, but consumer testimonials, even if somebody else says it, if it is on your website and connects to your ability to buy the product as a consumer, right? Like if you post links on your website that you can also buy the product from, the FDA considers that a claim about your product. Social media, including likes, if you like somebody else saying, hey, this product helped me with my arthritis, technically that could be considered a health claim. Even references to studies, even if you're not saying it, you say, some reputable study suggested so and so and so, FDA may consider that a health claim and still send out a warning letter or employ some other enforcement mechanism. So I think this is the easiest one, so I hope I get a nice chorus of answers here. But if drugs must be pre-approved by FDA and health claims make something a drug, then what can you do?
Don't make a claim.
Don't make any health claims. Don't make any health claims anywhere. So, of course, caveats. Just because you don't make a health claim does not make your product legal, right? As we discussed, there are other nuances. You still can't add an unapproved drug or new drug to food dietary supplements. FDA is less likely to find out about it, but still illegal. You may still need GRAS approval for food or new ingredient notification for a dietary supplement. And again, there may be state law issues. Plus, you have to comply with all other FDA requirements. Bless you. So what are the takeaways? One, the FDA likely does not have authority over smokables and vape pens, and they have limited authority over cosmetics, regardless of whether or not the item contains CBD. FDA has limited authority over any items in intrastate commerce, regardless of whether or not that item contains CBD. New hemp-derived substances may be added to food or dietary supplement without pre-market FDA approval, if not CBD, because FDA has determined that CBD is not GRAS, or generally recognized as safe. And you may have to notify the FDA in certain circumstances. And then health claims are frankly the quickest way to make your product into a drug, subject to FDA authority and enforcement. And that's it for me. We have time for questions. I'd be happy to take any questions you have. And if you think of a question later, feel free to email me, call me. My information is up there. I'd be happy to field any questions that you might think of later.
You mentioned the addition or the other cannabinoids that are available in the plant, CBG and CBN, or some that will be available in the plants that are grown this coming year. So if you go the route of using one of those, what guidance would you give if that plant will likely produce CBD at some percent? So for example, it might produce 10% CBG, but there's going to be some residual CBN, just like there is some THC.
Yeah.
What advice do you have about how to handle that? Because it's likely, would the FDA then have some ability to say, hey, there is CBD in there, even though you've never made a claim about that? And I've tried to avoid all the, any reference to it.
Sure. Well, there are no guarantees, right? But if you want to go by the book, as I stated before, the GRAS notices for the whole hemp seed, the hemp seed protein, they included in the GRAS notification that they had trace amounts of THC. And they were nevertheless, tacitly approved. And so I think, if you isolate the CBN, CBG, whatever else, to the greatest extent possible, and you have to be truthful in your GRAS notice, right? But if something like may include trace amounts of naturally occurring something in that realm, you might be okay. And then if they ask further questions, you have to answer, and maybe by then you'll have figured out a method to truly fully isolate that cannabinoid. Any other questions? Sir.
As far as you know,
Please use the microphone.
Thank you, Johnny Gilbert.
as far as you know, has the FDA taken any other enforcement actions besides issuing warning letters?
No. As far as I know, they have not. They issue about 15 warning letters a year. And basically in the warning letters, they state, please write us a response as to A, why you think we're wrong, or B, steps you are taking to come into compliance. Regardless of what any manufacturer who's received, that I know of, that's received one of those warning letters, regardless of their response or non-response, I'm unaware of any seizures of product. I am unaware of any recalls. Interestingly, Charlotte's Web received a warning letter, I think in 2018, and their answer was that they believed that CBD was marketed prior to GW Pharmaceuticals making their clinical investigations public for Epidiolex. I haven't seen their response. It's not publicly available as far as I'm concerned. I mean, maybe a freedom of information request, you might be able to get that, but I'm not sure like what scientific information or data they have to substantiate that. But I will say that this most recent spate of warning letters has included some stronger language in terms of enforcement. They've included that failure to respond could result in injunctions against sales of the product. But again, I have not seen any action other than warning letters up to this point. And it may ultimately be a moot point just because FDA, did have a public hearing. They took all sorts of comments. They are trying, according to them, they are trying to find a more efficient pathway to bringing some of these products to market. I know that about a week ago, Congress introduced a bill that would define CBD as a dietary supplement and thus just make everybody sort of go the dietary supplement route. It's too early to tell sort of, what the odds are that it will pass. But, I mean, Congress is pissed. They passed this farm bill and because of some of the senators who drafted it, one of which is from Kentucky, they specifically preserved the right for the FDA to regulate this thing under current standard FDA regulations, right? As opposed to just creating, they can amend a law whenever they want. But Ron Wyden, Merkley, and some senators from other states who had a hand in drafting this thing, the 2018 Farm Bill I'm talking about, have sent pretty strongly worded letters to FDA because, their constituencies, I mean, this is a lot of their livelihood, like you folks probably. And so I'm cautiously optimistic that if FDA doesn't fix it or FDA doesn't fix it to Congress's satisfaction, that sooner or later something will come down the line that'll make this easier to produce, assuming that there's, not some sort of mass adverse health event or something like that, which I don't think there will be, but who knows?
My question is, you can't be the first person to have thought of the idea of, we'll just submit an NDI letter.
That's right.
So are you aware of any reasons why everybody hasn't already done this, aside of not having thought of it?
I'm not sure. Well, I'm not sure if everybody hasn't done it yet. I to be honest with you, I haven't looked over the the list of INDs. So I wouldn't be surprised if, especially CBG or CBN, somebody has done it. But also, you know, it's a new industry. You know, there's a lot of disinformation out there, frankly, you know, and a lot of people sort of just jumped in with both feet as soon as the 2018 Farm Bill was passed, before then, when the 2014 Farm Bill was passed. And so, you know, a lot of people want to get rich quick without necessarily thinking about, and also, to this gentleman's point, I mean, the FDA is only sending warning letters, right? How much of a business risk is it necessarily if you don't make any health claims? And if CBD is the craze, right? So many people want to jump on that bandwagon as opposed to like doing the research and figuring out if CBN might work.
So a follow-up question then would be, the process of submitting the NDI letter. I've read one or two of them, and it looks like you have to provide an awful lot of information that is then publicly readable, accessible. So you could potentially be giving away some secrets, maybe, or your process a little bit.
Yes.
I'm wondering if that might be one of the reasons why perhaps there aren't if there aren't any.
It's getting a little bit out of my area of expertise because I'm not an intellectual property attorney. I mean, that's possible. I think that's possible. I also think that once you have this ingredient, for lack of a better word, approved as grass, you can add it to your own unique product, right? So I mean, I don't think you necessarily have to share the nature of the product that you're adding it to. Like you could take the hemp seed protein powder, you can add it to your own unique product.
Thank you for your presentation.
Sure.
The first one's kind of easy. I got a couple, and feel free to kick me out of the way. Mine's going. The warning letters that you referenced earlier, are those publicly available?
Absolutely.
Best place to get them?
If you Google CBD FDA warning letter, there's a page that has all the warning letters from 2015, I think it is, to 2019, as well as some explanation and further resources.
Thank you.
The FDA website is actually really accessible and good.
The second one might be a little more thick-headed. I mean, semantics aside, so we know the GW pharmaceutical product. I can never pronounce it properly, so I'm not going to butcher it. You know what I'm talking about?
I practiced in the mirror before I came here today. It's Epidiolex.
Epidiolex. So it has CBD listed. Again, semantics aside, CBD, if you were to take hypothetically a full spectrum product that contains 100 plus cannabinoids and do the new ingredient and submit that, if you put the disclaimer aside and you're not even remediating any of the CBD out of it, but it's in combination, so you have 1 through 99 plus CBD, would they say, nope, that has CBD in it, you're done?
Probably. I don't know what they would say, but that would be my guess. Just because they've come out and publicly said that CBD is not generally recognized as safe. There is a case that I read a long time ago that differentiated between an isolated molecule versus a naturally occurring. It was in some sort of red yeast, I think it was.
Red star yeast.
Yeah.
Red rice.
That's right. But that was sort of not necessarily the crux of the case. It was what lawyers call dicta, so it was sort of like an aside that they were mentioning. So I think that there's a defensible position that if you say, whoa, the ingredient is not CBD here, right? The ingredient in Epidiolex is an isolate of CBD. It's not a full spectrum extract. Will the FDA buy it? I don't know.
Okay. Last question is, you mentioned limited, I put access, that's not the right word, limited authority over cosmetics.
Yeah.
Can you elaborate a little more on that?
Sure. Yeah. So basically, what I meant by that is just that the before a cosmetic goes to market, the FDA, you don't have to go to the FDA and say, "Can I sell this?" Basically, right? And the FDA has also said that cannabis and cannabis extracts are not per se prohibited from adding to cosmetics. And the FDA, I don't know if like the cosmetics and dietary supplements just have great lobbyists or what, but the FDA sort of looks at cosmetics after the fact, right? They're reactive in this case, and so if it starts causing rashes, then the FDA is going to do something. But if you're not making medical claims and you're adding some CBD to something that you put on your skin to, I like the definition of cosmetic. It's like beautify, increase attractiveness or something. Then so long as it's safe, you're okay.
I have to differ with that. So
Sure.
Please use the mic.
it's not really a question. As far as I understand, CBD is a drug in the FDA's eyes, and putting CBD in a cosmetic is still considered adulteration for interstate commerce, whether it's a dietary supplement, food, or cosmetic, because it's still a drug going into interstate commerce. But
In their eyes.
That logically makes sense, but nevertheless, the FDA has publicly said that they didn't say adding CBD, they did say adding cannabis and cannabis-derived substances to cosmetics in interstate commerce is not per se prohibited. And I think there's also a difference between a new drug and an unapproved drug, and there are other definitions that apply to drugs and how they are administered. But I'd be happy to follow up on that. Sure.
So this has a little bit more to do with the claims that you were talking about. Is it specifically for packaging and marketing and anything that can be retrieved again? I run events, and so when a soccer mom comes up and asks me, what does CBD do? Sounds like there's a long list of things I'm not allowed to say, and I'm also not allowed to give anybody's personal experience with it. So what do you say?
Google it, I guess. I mean, if it's an event and you are not a product purveyor, but it looks like you are if you work for Wild, look, I mean, unless there is an FDA representative posing as a soccer mom and asking you that question.
I mean, I want to be compliant. I do, but
Right. Well,
yeah.
I mean, technically you should not be making any health claims, unfortunately, at this point. Even stating them verbally.
I was leaning into I experienced this and I don't necessarily say you'll have this. I say I use it for this, but it sounds like that's wrong too.
To be on the safe side, that's a great question.
And that would be a testimonial, like,
you just gotta get
I would see outside that t-shirt.
Yeah,
You can't.
I'm not a
Well, no, I mean, there are degrees to everything, right? So what I would say is if you want to be 100% safe and compliant, then I would not make that statement, probably. But I would reiterate that the FDA is sending warning letters to manufacturers who are making far more egregious statements on far more marketing materials. So.
So a lot of the claims you would make for cosmetic could be considered structural if it was not just saying, I mean, this eyeliner is going to make you more attractive. I mean, we say this.
Well, see, that's the thing, is that I think FDA would say that that is not a structural, right, beautifying is not a structure function claim, right? Is it the function claim of is it the function of the human body to look beautiful? I think so, yes, right? But I mean, technically, probably not.
I mean, if the CBD product says I'm going to look more attractive when I use it, I'm just still giving it.
Hey, take it up with the FDA. What can I say? I mean, at the end of the day, of course, everything is subjective, and we just have to go on how we interpret words, laws, etc., which is my job.
Absent of a ruling or a statement made by the FDA, and I'm just thinking for processors, growers, the whole industry right now, you look at, whether it was PepsiCo or Constellation I heard earlier, or all of these other Dannon Yogurt, blah, 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 all of these other large Budweiser, fill in the blank with whatever company you want, absent something from the FDA, is there just too much exposure for them to allow this industry to truly take off?
Maybe. I mean, I'm not sure exactly what you're asking, but
I'm asking, what is the next step, or what does, I'm not saying look in your crystal ball, I'm asking the next legal step, or the next thing that opens the doors.
before Budweiser jumps in with both feet.
Yeah.
Yeah. It would be a new regulation or policy statement from FDA, I think.
Does FDA have the authority to take more drastic measures? Like, I would worry about disgorgement of profits or something along those lines. A letter threatening injunction maybe, but, is there like a clawback? How bad do you think it can get under their current authority if they decided to change directions and stop doing letters?
I think they would have done it by now. And I'm not sure that they have the stomach for it, frankly, or the resources, but I mean, technically, they are not a law enforcement agency, so they would, communicate with the DOJ and, get the DOJ to send, FBI folks maybe. But again, it's in extremely rare cases, right? Where, somebody is selling something that is clearly and obviously a detriment to public health, and they keep doing it no matter how many times the FDA tells them to stop, right? So like a recall or something like that, the FDA does that, when there's E. coli and things like that. So I mean, they have, at the end of the day, sort of the full force of the federal government at their disposal, but that's in very extreme cases. Don't make CBD products that hurt people. If that's it, we ran a little bit over. Thank you for bearing with me, and I hope you had a great conference. And please feel free to email me or call me if you have further questions, okay?